Outrage over several trademark applications filed in the European Union, United Kingdom and United States for the terms George Floyd and I Can't Breathe. This follows a wave of Black Lives Matter protests against racial injustice and police violence sparked by the killing of George Floyd at the hands of police. In a video of the incident, Floyd is pinned down for more than 8 minutes and repeats the phrase, "I can't breathe," as an officer knelt on his neck. So what exactly is the legal recourse when an individual pushes to monopolize the use of such phrases? To talk to us about this, Pillay is from Adams & Adams Attorney. Good evening and thank you so much for your time tonight, Udi. It seems like such a surprising thing for an individual to want to take something that has been such a big part of this global movement and say, actually, I want to own this phrase and potentially make money from it in the future.
Right. The way we look at the law is that trademarks, in order for a trademark to be registrable, it must be capable of distinguishing the goods and services of one party from that of another. Now, whether or not these phrases comply with the provisions of the Act is questionable. These phrases arguably fall short of meeting this requirement, as the public is unlikely to view the phrase as a brand per se, but more likely to view it with a social and campaigning movement for which it is. And in addition to that, the Act also provides for phrases or marks that are not capable of being registered as trademarks if they are contra bono mores, where they contradict public policy or morals or give offense to a class of persons. Now, these marks are specifically excluded in terms of registration in terms of the Act.
It's interesting because this move has also been heavily criticized, right?
100%. The registration, so to speak, of the trademarks in the United Kingdom has been heavily criticized by the IP fraternity, even the public. So much so that it's led to those trademark applications actually being withdrawn. I think in the middle of June, Demetriou actually, through his company, withdrew the trademark application, and it was largely due to the backlash that he received from the public. So much so that him as well as his staffs have received threats.
What would one do typically once being able to trademark such a phrase?
Whether or not that phrase can be trademarked is highly debatable. So it has to obviously satisfy the requirements of the Act for something, for a phrase of that nature to be trademarked. And if for whatever reason, there's two hurdles that you need to overcome. One is from the registrar's perspective, where he will examine the trademark application and basically determine whether it meets the requirements of the Trademarks Act. If for whatever reason that hurdle is overcome, the next hurdle is an opposition where the trademark is advertised for any interested party or aggrieved party to oppose it. And so that opposition period is open to the public. So if you feel aggrieved about the application, you're welcome to oppose it at that point.
Are you surprised that this has happened in the first place?
Many trademark applicants tend to register these types of trademarks. Whether or not they're successful is highly debatable. As I said, it has to comply with the conditions of the Act, satisfy the requirements, and so on. So it largely is based on whether or not it can be a trademark.
Have we seen anyone on the African continent try to take their chances?
Well, we recently did a search on the trademarks register in South Africa, and so far nobody has applied for any mark that's similar or identical to Black Lives Matter or I Can't Breathe. So that's a positive sign.
All right. Well, let's leave it there for tonight. Pillay is from